Okay, I think that everyone who wanted to join us already joined. We will start the webinar now. Hello, everyone. Thank you for joining today's webinar. My name is Alexander Melnik. I'm a head of corporate and M&A practice at GOLAW firm. Today with me also my colleagues Oles Repchuk, our corporate and M&A practice associate, and Victoria Bublichenko, who is the head of tax, restructuring, claims and recoveries practice at GOLAW. A few words about GOLAW. It is the leading law firm in Ukraine operating in compliance with international standards. The firm operates for almost 20 years, since 2003, and has been recognized by prestigious international rankings such as Legal 500, Chambers and Partners, Who is Who Legal, IFLR 1000, Best Lawyers, and so on. For the last 8 years, GOLAW is ranked among top 10 leading law firms of Ukraine and currently holds the 4th position in the national ranking. Our client portfolio includes large and medium-scale business, national foreign companies, banks, financial institutions, private investors, and of course, we support non-governmental organizations and charitable organizations, both local and foreign. We would like to thank American Chamber of Commerce for the opportunity to hold today's event and share our thoughts and expertise about setting up and running NGOs in Ukraine. Today, we will discuss the peculiarities of setting up NGO or charitable organization, differences between the applicable legal forms, registration peculiarities, taxation, and other matters. In case any questions arise during our webinar, please feel free to put them into the chat and we will revert to them in the end. So, okay. First of all, I would like to show a few statistics facts. There is no doubt that the war forced the activity of NGOs and charity. And we are very grateful to these organizations because they are helping our country to fight the enemy. In order to understand the change, we brought several numbers to the slides. So as you can see on the left, in 2021, almost 800 charitable organizations were registered in Ukraine for the whole year. But after the beginning of the full-scale invasion, the number of charitable organizations that were founded and registered during 1 year rocketed to the amount of 6,000 and almost 4,400 organizations. And it should be also taken into account that during first 2 months or 1.5 months, the registration was partially blocked. So the rise of registration is drastic. As to the public association, the numbers are different. According to the statistics, during 2021, number of public organizations registered in Ukraine was 4,400, whereas in 2022, the number increased only by 2,600. So we see that the registration of a charitable organization is more often occur. We also feel it in our works, as a lot of clients asked us to register NGOs, and they have a lot of questions regarding the activity of NGO in Ukraine, and we know this typical question. Therefore, we wanted to share it today with you. So, first question that our foreign clients ask is, how can a foreign NGO conduct its activity in Ukraine during martial law? The answer is generally in the same way as it was before the martial law. There were certain limitations for the registration actions, as I mentioned, during the first few months of the war, but currently the possibility to register NGO is unblocked and fully available, except for applicants from aggressor state, of course. So If you have foreign NGO, you can conduct your activity by having agreement or representatives here in Ukraine. But in order to conduct the activity fully in Ukraine, a foreign NGO shall have a legal presence in Ukraine. And it can be done in two ways. First is incorporation of a legal entity. Second is registration of a separate subdivision of foreign NGO. Choosing the appropriate form is essential because it has different legal status and outcomes. Therefore, in this connection, the logical question arises: what is the difference between the legal entity, NGO as a legal entity, and a separate subdivision of foreign NGO? And the first is, of course, their legal status. Legal entity operates independently and has its own legal personality and capacity. It represents itself and interacts with other entities as an independent legal entity. A subdivision is actually a representative office of a foreign legal entity, of foreign NGO. So it's part of foreign NGO, which is located in Ukraine. Activities of subdivision usually fully correspond with the activities of its parent company. Also, legal entities and subdivision have different constitutional documents. In most cases, legal entities operate on the basis of charter, and the legislation establishes special mandatory requirements for its content. Meanwhile, the separate subdivision is governed by regulation, which is not compulsory because our legislation does not set special requirements to the content and form of these regulations. However, it is recommended to have these regulations in place to formalize the internal rights, duties, procedures, and so on. Also, these types of legal presence differs by the management. As a general rule, legal entities are managed by a sole director or board of directors. The powers of sole director or board of directors are regulated by charter. In contrast, also the legal entities have, of course, the gathering of general meeting of participants or founders. It varies from the form to form. In contrast, a subdivision is governed by a head who acts on the basis of power of attorney, which is issued by foreign NGO. Respectively, all major decisions are adopted by a parent organization. Another crucial difference between these two legal presence forms is the process of incorporation or registration. Generally, incorporating legal entities is predictable and comparatively easy procedure which takes at maximum 10 business days, including preparing all necessary documents. In its turn, registration of a separate subdivision of foreign NGO is a complicated and time-consuming procedure, and it poses great risk for the project because standard term, law-established term for the first step in registration of subdivision is 20 business days. Thus, in case something wrong with the documents or other basis for refusal occur, you can lose more than 1 month for resubmission of documents and setting up it properly. Also, taxation. In general, taxation does not greatly differ. Both options are not profitable, but taxation of legal entities falls under Ukrainian legislation only, whereas in case of subdivision, certain operations in certain cases can be subject to taxation rules of the state of registration of its parent company. Another difference is staff legalization procedure. If you set up a legal entity in order to employ foreign staff, Respective work permits shall be obtained by the NGO before their employment. Then the employee gets a visa and afterwards temporary residence permit. In its turn, for separate subdivision, obtaining of work permit for foreign employees is not required, and this significantly simplifies the legalization of stay in Ukraine. And a few words about financing. Legal entities are financed through donations, grants, sponsorship, other fundraising activities. It can be also membership fees and so on. On the contrary, financing of subdivision is usually done through the parent company. So the difference is generally clear, but another question occurs: what form should you choose? And in this answering this question, you should look on opportunities which provided to you by each form. Incorporation of legal entity provides the following opportunities. First is possibility to participate in tenders and grant programs where the eligibility criteria of the participants to have a legal entity registered in Ukraine. Also, as we mentioned, looking on the term of the incorporation of legal entity, which takes several days. So in case you have to start the project as soon as possible, the proper choice will be to set up a legal entity. Also, a legal entity can be incorporated in cooperation with other founders. Therefore, if your NGO have a local partner or want to have a project with another entity, this option will be suitable for you. In addition, legal entity is the separate and independent legal structure that governs itself and represents itself and function independently. As opposed to a legal entity, separate subdivision is recommended to incorporate in case, for example, when a parent company is well known worldwide or in several countries already have projects, financing, branding, and so on, staff well educated. So in these cases, it may be easier to gain additional financing and to use the funding that the NGO already has by establishing subdivision in Ukraine. Also, it's suitable when parent organization has a huge amount of assets and is able to use these assets in Ukraine. Also, a separate subdivision corporation is a reasonable option for an organization that has already provided charitable activities through authorized individuals or other organizations directly or have some agreements. So you will not have to reconclude the existing agreements. And it is suitable in case the time is not a crucial matter for you and you want to employ a lot of foreign staff. So if based on the above mentioned criteria, you choose to establish, for example, a legal entity, there are also several options how you can proceed. The Ukrainian law doesn't define the term NGO or non-governmental organization. And this fact often confuses our foreign clients. Ukraine proposes two general legal forms of non-governmental organization which can be used. It's charitable organization or public association. Of course, they are different, and the difference is mostly referred to their purpose. So in Ukraine, charitable organization and public association are both legal entities that operate based on different legal framework and have different purpose. A charitable organization, commonly known as the charity or charitable foundation, is a legal entity established for the purpose for carrying out charitable activities, gathering funds and distributing them between different beneficiaries. They are governed by the law of Ukraine on charitable activities and charitable organizations and are required to meet certain criteria in order to be registered as such. Charitable organizations are focused on providing social assistance and support to vulnerable individuals or groups, those in need, improving the quality of life of communities, addressing social issues such as poverty, education, health matters, environment, and so on. On the other hand, public association is a legal entity established for the purpose of bringing together individuals who share common interests and goals. Public associations in Ukraine are governed by law of Ukraine on public associations and can be established for various purposes, including cultural, social, professional, rights protection purposes, in some cases political matters, and so on. Public associations are focused on protecting the rights and interests of their members and promoting their common goals and interests. So, charitable foundations are focused on carrying out charitable activities, while public associations are focused on uniting individuals and with common interests, goals, and promoting their interests. Charitable organizations typically rely on donations and grants from individuals, corporations, and from funders, governmental bodies, and so on. Public association can also be funded by membership fees and other fundraising events. So once you decided to establish charitable organization and public association, you will also have to choose one of the forms of these organizations. Speaking about charitable organization, there are 3 forms of charitable organizations which can be registered. First is a charitable association, which can be created by at least 2 founders and acting on the basis of charter. It can also have other participants except founders after it was established. Charitable institution acts based on the Constituent or Founding Act. One of several founders can transfer their assets to achieve charitable goals. A founding act can be also made in the form of will or testament. It is crucial to underline that founders of a charitable institution do not participate in management activities of the institution. And third form is charitable foundation. Charitable foundation is the most common form of charitable organization in Ukraine. The charitable foundation can be created by one or several founders. Can be legal entities or individuals. It can also have other participants except founders, and its participants are not obliged to transfer any assets or money to achieve goals of charitable activity. It also acts on the basis of charter. As to the public association, it's much more easier. There are 2 forms. The first form is public organization. It is an association whose founders are members, which are individuals only, and public union, where founders are legal entities. But individuals are able to participate in its activities. So the main difference between these types of charitable organizations, public association, is the way they are established, who their founders are, what is their quantity, how they will be funded and managed. As we mentioned before, one of the crucial differences between subdivision legal entities is the process of incorporation, because it differs significantly. Therefore, we propose to briefly discuss the registration procedure, and I would like to pass the word to my colleague Oles. He will shed some light on this matter. Oles, the floor is yours.
Thank you, Alexander. I'm delighted to be here today, and I would like to welcome you all here this morning. I plan to say a few words about the incorporation process of legal entities and separate subdivisions. I would like to divide the incorporation of charitable or public associations as legal entities and separate subdivisions as their incorporation process is different. I'll begin with separate subdivision incorporation. Initially, it should check whether the foreign organization is non-governmental and whether its charter documents concern charity or public activities. It is crucial to underline that foreign organization status in the country of location will be defined as the name of its office in Ukraine. For instance, an office of a charitable organization foundation in Ukraine will have the name affiliate. Meanwhile, an office of another NGO in Ukraine will have the name subdivision. It is essential to consider in its incorporation documents as the incorrect name of the organization form can be the ground for application cancellation by the Ministry of Justice. For subdivision incorporation, the parent company shall issue the resolution of its management body, for instance, the board of directors or president, devoted to the subdivision incorporation, power of attorney for the local representatives, and the power of attorney for the subdivision's head. Additionally, the following documents shall be submitted for incorporation process. Copy of a document confirming the registration of a foreign NGO. It can be an excerpt from trade, court, or another official register. Copy of charter documents of foreign NGO, ownership structure, a document of an ultimate beneficial owner of a foreign NGO, documents confirming the registration of an NGO in the country of its location. Please be reminded that all documents shall be notarized and apostilled for their validity in Ukraine. Sometimes applicants submit a subdivision's regulations, among other incorporation documents adopted by the foreign NGO. We would like to underline that this document is not mandatory for incorporation purposes under the legislation. Reviewing this document by the state register can provoke them for additional amendments that can negatively influence the incorporation process. Please note that you shall prepare all mentioned documents in 2 copies and at least 1 notarized copy. This is important because the registration of subdivision by the Ministry of Justice is a first step of incorporation. To conduct activities in Ukraine, the subdivision shall be registered with the statistic and tax authorities and open a bank account. For instance, to register a subdivision as a taxpayer, you shall also submit the original document of an authorized body of foreign state confirming the registration of NGO, among other documents. In practice, registration of NGO subdivisions by the Ministry of Justice is a complicated process even for experienced local lawyers. The state registrars have 1 month to review the submitted documents and willingly review the papers near the deadline. Even insignificant remarks in the document can be a deal breaker for their approval by state register. It is crucial to know that incorporation procedures of legal entities and subdivisions are different. Therefore, subdivisions shall additionally request the statistic authority to receive the unique code. The process can take several business days. In contract, such code will be assigned automatically after state registration for legal entities. After registration of the subdivision, you have 10 business days to register it and its parent company as taxpayers in Ukraine. It is important to say that the subdivision cannot be included in the tax register without a unique code. Therefore, planning the time effectively and having the necessary documents timely is highly recommended. Issues devoted to the bank account opening and staff legalization we will review separately. That's all I have to say about subdivision incorporation. And a few words about incorporation of legal entity. To begin with, a legal form of the organization should be chosen in accordance with the purposes. Next step is a name of the organization should be chosen. The name should not be already registered and should not conflict with any existing trademarks or brands. For comparison, the name of a separate subdivision of an NGO shall be identical to the name of its parent company. The next step is a preparation of the organization's incorporation charter and the founder's decisions devoted to the legal entity incorporation. The charter outlines the organization's purpose, goals, structure, and other features under the legislation. It can be bilingual and signed by the founders. The charitable or public associates shall be registered with the Ministry of Justice too. In contrast with the separate subdivisions, legal entity registration is transparent and quick. It can take no more than 5 business days. Meanwhile, it is recommended to communicate and cooperate with the state registers during the registration and consider their remarks. Notably, public organizations incorporation in the Ministry of Justice automatically registered them in the tax authorities as non-profit organizations. It is crucial to underline if a charity organization involves volunteers in its activity, such an organization shall be included in the register of the charity organizations that involve volunteers in their activities in Ukraine after its incorporation. Issues concerning the account opening, bank account opening, and staff legalization, we will review separately. Thank you, Colin.
Okay, thank you, Les. Of course, registration doesn't mean that NGO already operates fully. For this step, the next step will be opening of the bank account. And I also wanted to highlight a little bit about the registration, as mentioned by Les, how it's happening in practice. So in case you choose to register a subdivision, this is made only by Ministry of Justice, so you cannot refer to any other registrar. And the peculiarities of their review of documents, unfortunately, they tend to provide the decision on the registration on the last days of the registration term. So 20 business days, it's a lot, it's 1 month. And when the documents return with refusal, you will lose another week or more for getting these documents if it's made by post, and then to resubmit them. So some clients who tried to register the subdivision and after several failures referred to us, they lost about 4 to 5 months, which is very crucial. Okay, and about bank account opening. It became one of the challenges for this for the establishing NGOs in Ukraine. Unfortunately, martial law, fraudulent actions of some people who make money on war and launder money through charitable organization forced banks to enhance their KYC procedures as never before. In practice, bank account opening for the NGO can now take up to 2 months. And whereas before the war, it could be done during 1 week. So when setting up NGO in Ukraine, you shall be prepared to provide additional information and documents to the bank. And in order to successfully finish the bank account opening, you need to understand what the bank will analyze in the first place. So first and the most crucial question is the beneficial owner structure. So it shall be transparent and shall be provided to the bank in the form they wanting you to provide. It can be the case that in some cases the organization have no beneficial owners within the meaning of our law. And in these cases, you shall be prepared to prove this position and have the documents which will confirm it. In practice, we see the situation that the banks interpret the term beneficial owner in other way, rather than it is defined in our law. And for example, we had one case when the organization was already registered and client referred to us in order to assist them for opening bank account because they couldn't manage it on their own. And when we started the process of the bank account opening, bank requested the disclosure on information about UBOs. In its turn, in the register, it was stated and registered by our registered Ukrainian that the NGO doesn't have ultimate beneficial owners. But bank had another vision on this situation, and they demanded client to have disclosed all individuals who are in management and in the list of members, of founders of the companies who founded the NGO in Ukraine. So another question which is analyzed by the bank is purpose and mission of organization creation and its activity. It shall be confirmed by the documents. For instance, they ask for previous experience, previous projects. They search for website or also search for information in internet. So you shall be prepared to provide information about previous achievements, and if you have or previous experience in NGO activities or charity activities, implemented projects, and so on. Also, they want to understand the main source of funding, types and list of donors who will transfer funds, expected amount of this funding, and of course, directions and distribution mechanisms and intended purpose of these funds. If you have all this information and can answer this question, the registration process, opening of the bank account process will have no problems. And also a few recommendations. So we recommend the NGOs setting up here charitable foundation or public association or subdivision to have in place another copy of all documents of foreign non-governmental organization who is the founder, because it will be requested by the bank, and if you have only one copy of the document, they will be submitted to registrar and you cannot get it from them after the registration. Also, if the parent company or founder is US resident, the form W8 or W9 shall be submitted, signed by authorized person of foreign NGO. Also, what would like to say that all these documents which are issued by foreign in the foreign state shall be, of course, legalized and then translated into Ukrainian, and these translations shall be notarial. Basically, that's all, I think. And I propose to move to another question, which is also very crucial. I propose Victoria Bublichenko to step in and tell us a little bit more about taxation of these different forms of legal presence. Victoria, please feel free to tell us about this.
Thank you very much, Alexander. Dear colleagues, I'm happy to welcome all of you here today, and I will be delighted to highlight some tax issues which are important for non-profit legal entities and separate subdivisions of foreign NGOs. So let us start with non-profit legal entities. The first issue and question which may arise, do they pay in Ukraine here corporate income tax? Under the tax laws of Ukraine, they will not pay this tax if they meet some requirements. Basically, the part of these requirements is established for organization, and another part is established for the way of how the organization will use its income and its profit. Speaking about the first part of requirements, for the purposes of corporate income tax, the entity or other organization will be deemed as non-profit, and this means that will potentially have the possibility not to pay corporate income tax here in Ukraine. Such an entity must meet several requirements, such as it must be established in accordance with the procedure defined by the laws of Ukraine regulating the activity of the relevant non-profit organization. Another one requirement is that constituent documents of such organization must contain a prohibition on the distribution of received income or profit or parts of this income or profit among the founders, members of such an organization, some employees, members of management bodies, and the persons related to them. One more requirement is that the constituent documents of the organization must provide for the transfer of assets to one or more non-profit organizations of the corresponding type, other legal entities providing non-state pension provision in accordance with the law, or inclusion in budget income in case of termination of this legal entity. And one more requirement, such organization must be entered here in Ukraine by the tax body in the register of non-profit institutions and organizations. If all these requirements are met by the non-profit legal entity or another legal entity which positions itself as non-profit, there is a chance that the company, the organization, will not pay corporate income tax. As an example, the tax legislation of Ukraine says that among such organizations can be public associations, charitable organizations, pension funds, and other legal entities if they meet all these requirements which I've mentioned. Just one small remark about representative office of a foreign NGO. Such an entity cannot be registered in the register on non-profit organizations due to the fact that actually it's not the legal entity. I would like to ask Alexander to switch to the next slide. Thank you. One more important thing, if the entity meets all the requirements I've mentioned, then one more requirement must be taken into consideration. If the organization receives some income profit, it must be used exclusively to finance expenses for the maintenance of such a non-profit organization, implementation of the goals, tasks, and directions of activity defined by the founding documents of the organization. In case all these requirements are met regarding the ways of how to use income and the requirements which we have already discussed, the organization will not pay the corporate income tax here in Ukraine. It's very important to meet all these requirements during all the period of activities, because otherwise, if something will go wrong, there is a high chance that the organization will lose its status of non-profit, non-commercial status. And if there are some transactions which provide for non-targeted use of assets, there may be tax consequences, negative tax consequences in the form of the need to pay corporate income tax from these non-targeted use of assets, and with further exclusion from the register of non-profit organizations and loss of non-commercial status. One more important remark in this context is related to the imposition of martial law in Ukraine. For the period of martial law, there is a special rule that the transaction of transfer of assets for the defense needs, even if it doesn't correspond to aims and other goals of the non-commercial organization, which are defined in its founding documents, it will not be deemed as the transaction of non-targeted use of assets. So in case the organization will share some assets or funds to the armed forces of Ukraine or other special institutions which provide for the defense of the country, this will not lead to negative consequences in the form by a usage of non-profit status and any kind of additional tax assessment of corporate income tax as if the transaction was non-targeted. One more important issue here that actually the non-profit organization can be a payer of other taxes here in Ukraine, but this issue is quite individual and depends on the particular situation. It depends on the activities of this organization, of existence of taxable objects or performance of any specific transactions by this non-profit organization. For instance, the non-profit organization can be a VAT payer. Sometimes it can be registered voluntarily, sometimes in obligatory mode, but it can be a VAT payer if carries out taxable operations. Another example is that if the non-profit organization hires here in Ukraine employees, in such a case, the organization will perform the function of a tax agent regarding the personal income tax, military levy, and unified social tax. The non-profit organization will withhold them and pay them for employees, and of course will file some special forms of tax reporting regarding these taxes and incomes. One more example, the non-profit organization can be a payer of land tax, for example, or tax for real estate other than land if there are taxable objects, for instance, the respective real estate owned by the organization. So, as we can see, the situation with other taxes is quite individual. I would like to ask to switch to the next slide. Thank you. The next issue, which I would like to discuss today, some tax points to be highlighted for the representative offices, separate subdivisions of foreign NGOs. In this context, there are important issues related to some organizational moments, such as tax registration, and of course, regarding payment of taxes. The first issue I would like to highlight that in such a kind of presence, there is a requirement under the laws of Ukraine that the non-resident, which incorporates here in Ukraine a separate subdivision, as well as the separate subdivision, both must be registered with the Ukrainian tax authorities. There is a general rule that those non-residents which carry out activities in Ukraine through separate divisions are required to be registered with the tax authorities. There are separate procedures for registration of separate subdivision and for registration of the non-resident. Speaking about the tax registration of the non-resident, the general term for this is 10 days after the separate subdivision is incorporated here in Ukraine, and the tax authority, which will be the place of tax registration of the non-resident, is the tax authority at the location of the separate subdivision. To become registered in the tax authorities of Ukraine, the non-resident must file a special package of documents, which usually includes special application for registration, extract from business register, the document identifying the identification code of this non-resident if this information is not present in the extract from the business register. Also, the package of documents will include the documents proving the powers of representatives of the non-resident, for instance, the power of attorney, And also the non-resident must submit the document on incorporation of a separate subdivision. After the tax office receives all these documents, the tax authority will make the decision on registration or the need to correct something in the documents filed to become registered. After all the procedures with registration are fulfilled, there will be a special certificate issued in address of the non-resident regarding its registration with Ukrainian tax authorities and containing a special identification number of the non-resident. As to the tax registration of separate subdivisions, the registration is usually performed based on the data from some special Ukrainian state registers, but in the event that the required data are not included in such a register regarding the separate subdivision, the tax registration is performed after incorporation of a separate subdivision together with the non-resident and based on a separate package of documents which the separate subdivision must submit to the tax office within 10 days after its incorporation. For instance, this package of documents will also include a special application form for registration, the copy of the document proving the identification code, and the document on accreditation of this separate subdivision. In the result of consideration of all these documents, the tax authority will also take the decision on tax registration or the need to introduce some changes or other remarks regarding the documents filed. And if everything is fulfilled smoothly, no issues arise, and the tax authority is ready to register the organization, it will submit for the separate subdivision a certificate on tax registration, which will contain the tax number for such a separate subdivision. So, briefly speaking about the issue of tax registration, both non-resident and the separate subdivision shall be registered with the Ukrainian tax authorities. And after such a registration, each entity will get the certificate on registration and its own tax number. Speaking about the issue of payment of taxes, of course, corporate income tax in the first turn, there will be no tax implications related to corporate income tax in the event that the separate subdivision performs non-commercial activities. Only non-commercial activities. In the event that some activities one day will comply the requirements which are usually introduced in the context of commercial representative offices. In other words, permanent establishment, there may be the tax consequences related to the corporate income tax. The main point is that if one day the representative office will start performing some commercial activities aimed at receipt of income. In such a case, there may be the need to pay corporate income tax and, of course, to declare everything to the tax office, to submit tax reporting and alike. One important note that if one day the activities of this separate subdivision will become commercial and will be aimed at the receipt of income, that will be the responsibility of the non-resident, not of the separate subdivision, to control all the issues related to the corporate income tax. Under the general rules of the tax laws of Ukraine, if a separate subdivision of the non-resident performs truly commercial activities. In such a case, the non-resident is obliged to submit tax reporting regarding the corporate income tax. It is obliged to be registered as the payer of corporate income tax, and of course, it is obliged to pay this tax. So this issue to be controlled, well, if the separate subdivision doesn't plan any commercial activities, it will not generate income, commercial income. There will be no corporate income tax implications. Speaking about other taxes, the situation is quite similar to the situation of non-profit legal entities. Depending on transactions, existence of some taxable objects, there will be a need to pay other taxes here in Ukraine. Again, the taxes related to hiring employees in Ukraine, performance of function of a tax agent regarding such employees with payment of personal income tax, military levy, and unified social tax. Also, there may be a need to pay land tax, tax for real estate, if there is a kind of special real estate owned. And there is quite interesting situation with VAT, as far as some general rules which regulate the order of registration of the taxpayers as VAT payers. These rules don't directly provide that non-commercial representative office or separate subdivision can be registered as VAT payer. So under the general rules, such registration is not provided. In conclusion, I would like to say that in each individual case, it's reasonable to estimate all the tax issues with all the other issues which my colleagues have already mentioned and will mention in addition. When we estimate all these factors together, it's possible to choose the best option for the particular situation or how to enter here in Ukraine in the sphere of non-profit organizations, and how it will be more reasonable and better to be present here. Thank you very much for your attention, and I would like to give the word to my colleagues again.
Thank you. Thank you, Victoria, for sharing thoughts about taxation. What we would like to discuss also is the crucial question about the legalization of foreign staff in Ukraine, because there are different options for this, and different options are used in different ways by organizations, and all of them have their pros and cons. So I again ask Oles to share more about this question. Oles, please.
Sandra, thank you for this opportunity. The core of any organization is its staff. Therefore, the legalization of the foreign team is an essential part of the presence in Ukraine. We would like to remind that citizens of foreign countries with a visa-free entry procedure may temporarily stay on the territory of Ukraine for up to 90 days within 180 days. Citizens of countries with a visa entry procedure can stay on the territory of Ukraine for the period defined by their visa, which is primarily 90 days. For foreigners, the foreigners shall leave Ukraine after the expiration of the specified terms. At the same time, a more extended period of stay for foreigners on the territory of Ukraine may be needed to achieve their goals. We would like to divide of legalization of staff in legal entities and separate subdivisions. There are several options for legalizing foreign staff in Ukraine, depending on their status in the organization. In charitable organization in form of legal entity, foreign staff can be employees or volunteers. Initially, foreign employees shall obtain a work permit in Ukraine for 1 or 2 years. Practically, the procedure can take up to 7 business days. Meanwhile, the organization shall pay an official fee for work permit obtaining for each foreign employee. It is approximately $340 for a 1-year work permit and $540 for a 2-year work permit. After the work permit receiving, the employee shall obtain visa type D04 in the Ukraine embassy abroad and enter the territory of Ukraine by using their visa. For foreigner volunteers, not necessary to obtain a work permit in Ukraine. The charity organization shall prepare initial letters for each invitation letters for each volunteer, among other necessary documents. Additionally, such organizations shall be included in the register of charity organizations that involve volunteers in their activities on the territory of Ukraine, as we mentioned before. After the invitation letter receiving, each volunteer shall obtain visa type D10 in the Ukraine embassy abroad and enter the territory of Ukraine by using this type of visa. I would like to underline that in both of the options, volunteers and employees shall enter the territory of Ukraine using their type D visas only. After receiving visa, employees and volunteers are able to obtain temporary residence permits in Ukraine. Temporary residence permits are issued for 1 year by the Immigration Service Department of Ukraine. However, currently, the law prescribes extensions for temporary residence permits. The temporary residence permits that expires after February 24, 2022 will be valid during martial law and 30 calendar days from the martial law termination or cancellation date under the current legislation. We would like to mention that during the preparation of temporary residence permits, each foreigner should be carried out activities in the city of a temporary address registration in Ukraine and be ready for an audience with Immigration Service representatives. Consequently, we recommend foreigners staying in the territory of Ukraine for 2 or 3 weeks after submitting documents for the temporary residence permit in Ukraine. However, for employees of representative office or foreign NGO incorporated in the territory of Ukraine, obtaining a work permit is not required. According to an analogy with volunteers, they should obtain a visa type D07 and enter Ukraine based on this visa for further temporary residence permit purposes. Okay, that ends the last part of my talk. That brings me to the end.
Okay, I just wanted to add, thank you, Les. Wanted to add a few words about volunteer visa and D4 visa. So involving volunteers doesn't mean that these foreign people are employed with the Ukrainian legal entity. So the volunteer cannot be paid by the local NGO a salary. It can be only a compensation of the costs incurred by a volunteer when he performs his volunteering activities. That is crucial to understand. So this scheme is applicable when, for example, foreign NGO has its own staff employed with the foreign legal entity, and they setting up a legal entity in Ukraine and send their foreign staff here, but in order to extend their stay, they can get them this D10 visa. And in this case, the salary usually is paid by the foreign NGO, and D10 visa is only the basis for such a foreigner to be here in Ukraine. It's just crucial to understand. Okay, here you can see our social medias. Please subscribe. We often share interesting analytics, newsletters, and so on. And while you're subscribing, we see that we have several questions here in chat. So first was about the sharing presentation. Of course, we will share our presentation with all the attendees who registered for the webinar. And we have questions referred to the speech. So are there any limits on amount to be spent on staff and other administrative expenses? Victoria, I think it's mostly to you. I think that there are limits when we talk about legal entities, public associations and charitable foundations. If I'm not mistaken, it's the 20% of expenses can be directed to the administrative needs. Victoria, am I correct?
Yes, Alexander.
Okay, and about the UBOs, and as of for UBO, do you consider a founder of a not-for-profit founding entity as a UBO, or it is only its management members who are UBOs? This is a very interesting question, because if we will analyze the law, most of the cases, none of these persons will fall under the definition of UBO provided in our legislation. However, if we speak about the founder of not-profit founding entity, I think that in most cases it will not be a UBO. If we speak about management of this not-profit founding entity, in certain cases, they can fall under the definition of UBO. This is because depending on the type and form of public association or charitable organization, from the moment of creation of the entity, the founders lose their status of founders and they become participants, not in all cases. And in case the organizations will be joined by other participants, so it can be the case then the highest management body of the entity is the gathering general meeting of participants. Imagine if we have 100 participants, then none of them will fall under the definition of UBO. If we speak about one founder and it's not-profit organization registered in foreign state and no other participants in Ukrainian NGO, then potentially management of this foreign legal entity can be deemed as UBOs, because the definition of UBO prescribes that the person have the influence on the activity of legal entity. So in order to answer your question correctly, we shall analyze the situation in detail. Another question from Katya. So it means a subdivision activity is registered for taxes, but can have no activities to report.
I will comment on this. In case of registration of subdivision, as I've already mentioned, both the subdivision and the non-resident must be registered in Ukrainian tax authorities. And in fact, yes, it will depend on factual background of activities and transactions of the subdivision here in Ukraine. I think that there may be an option that there will be nothing to tax. But of course, it will depend on what you are doing here, what assets you have here, and which transactions do you perform. Speaking about the registration of the non-resident, it's just a kind of a formal requirement, and I would say that it will matter only in case there are some tax consequences related to the corporate income tax. Usually the non-residents are responsible for all the issues related to this tax. And speaking about the subdivision, It has its own taxes. It will not deal with corporate income tax, but it will deal with other taxes. I suppose that at least employees will be hired. So in this context, you will have to pay taxes for them. But speaking about other activities, it will depend on the situation, what you are going to do here in Ukraine.
And another question from Katya, we have about 20 to 80%. What is considered administrative expenses? Staff too? Yes, staff is considered administrative expenses too. And basically, it also includes office and other expenses which provide the activity of an NGO. Mostly, of course, refers to charitable organizations, and in order to not lose the status of non-profitable organization, this proportion shall be maintained. Correct, Katya. You have to keep the expenses of structure and staff under 20%. Okay, so no other questions we see here. Here on the slides, you can scan the QR code. Our websites also, we have this beautiful picture of ourselves with our contacts. Please feel free to ask any questions to these simple emails. We will be happy to answer them and to provide any assistance regarding the Ukrainian law establishing NGOs and any other questions related to matters of Ukrainian law. Thank you for joining today's webinar. Please stay safe, subscribe, and we'll keep in touch. Goodbye.